Hi, I'm Lynsey Harrison and I'm head of Clarion's Contentious Private Client team, and I'm here again today to have a conversation this time with Jeremy, who's a solicitor in the team. So today we're going to be discussing a really important part of challenging the validity of a will, which is gathering the evidence contained in the will file, normally done at the outset of the matter. So firstly, Jeremy, why would someone request a copy of the will drafter's file when they're contesting the validity of a will?
Well, just the first point to mention on wills and will files is that when we're talking about requesting the will file, we're generally talking about professionally prepared wills, as you said. So that's a will prepared by a solicitor or a will writing company or another professional, as opposed to a homemade will. And as we know, a will itself, when you look at the will itself, it's fairly black and white, or literally black and white. Although you can find maybe some issues with the will when you look at it, so there may be some visible issues with the signature maybe for the testator, it might be shaky, there might be spelling errors, so you might be able to glean some evidence just from the will itself, but what you can't always glean, or probably can't glean, is actually how that will came about. So that's why we generally want to request the will file. And when you're doing that, a well-kept will file generally should be able to tell you a few things. So, for example, instructions, so how instructions were given by the testator to the solicitor, say, in this example, and also whether it was actually the testator giving the instructions, because it's not always the case that the testator is giving the instructions, although obviously you'd expect they would. Second thing you might see is what matters were discussed with the testator, so that might be their family, their estate, sort of other issues, sort of relevant medical conditions they might have. So a well-kept file should have some detailed attendance notes, file notes to talk about those aspects. Third thing you would expect to see is an explanation as to what the terms of the will are, and how they were explained for the testator. So that could be at those meetings or during those telephone calls, but also subsequently in writing, from the solicitor writing to the testator saying this is what your will is going to do. Are you happy with that? Fourth thing you might see as well is the will drafter's assessment of the capacity of the testator. So what questions they asked to ascertain capacity, what the answers were, whether any consideration was given to getting a independent capacity assessment, and if not, why not, those sorts of things. And the final thing you'd expect to see is how that will was executed. So if it was in the solicitor's office, you'd expect to see some file notes about the execution, or was it executed at home, and if so, you might want to then consider contacting those witnesses if you are challenging it. So all of those things are really helpful when you're considering whether to challenge the will, because if you're looking at things like capacity or knowledge and approval or undue influence, which are all those common heads of claim, then you can get a lot from the will file to sort of help both support a challenge but also defend a challenge as well, if you're looking at that angle.
Yeah, it's just looking at the reasoning behind all of it, isn't it? Why it happened. Yeah, absolutely. And what does a will file tend to look like?
So it can take different forms. So you might have a statement from the will drafter, sort of almost like a witness statement in some cases, where they're going through all the points you've raised in your Larke and Nugus request. Or it might be a letter that does the same sort of thing, together with a full or partial copy of the file. And it's always worth, I think, really scrutinising that initial response. Because, for example, in a case I had recently, the solicitor's will file didn't include any correspondence from the firm to the testator in writing saying this is what your will is doing, no draft will or anything like that. So I raised this with the solicitors, and they said that actually no, we didn't send any of that out to the testator. So that immediately sort of triggers, or did they actually understand what the will was doing? And particularly in that case, because there was a trust that was fairly complicated and not that bespoke. It had the sort of added bits to it that were quite unusual. So you kind of did raise that question as to whether that testator really understood what was going on with their will.
Yeah. And you mentioned there Larke and Nugus, not Larke and Nugus, some people call it, don't they, different things. And that's what we're talking about, isn't it? That is the letter that is sent to the solicitor to ask all these questions, or to the will drafter to ask all these questions. And so if a solicitor or will drafter receives that request, how should they respond?
So best place to start probably is the Law Society's practice note on disputed wills, which has really developed over the years, and that sets out your best practice, and a lot of information is in there about how you should deal with those requests. And and what sort of steps you should be taking. Best practice in that note, I think it says, is that it's 2 to 3 weeks is what you would expect. Whether that's always the case, I don't think it is it really? So that sort of thing is really helpful to look at that note and to see what your duties are, and particularly if you're looking at the executors, bearing in mind that a will file is confidential initially, obviously, to the testator when they're alive, and then after their death to their personal representatives or the executors. You need to then consider, do I need to get their consent, and how am I going to get their consent? So I think acting promptly is always an important thing to consider.
Mm-hmm. Absolutely. And that brings us to the question of costs of preparing it. What should people really be aware about when they're requesting this information?
So they should be aware that the solicitor preparing that response can charge a reasonable fee, which is open for debate as to what reasonable is. And also they can charge for photocopying if they need to, although many files are electronic, so maybe you don't see that as much as you used to. So I think it's always a good practice to agree with the solicitor that you're dealing with what their fee is going to be and how they're going to charge, and then sort of take it from there in terms of getting the actual file from them.
Mm-hmm. And I guess it's checking who's going to actually pay that fee, whatever it is, whether it's going to come from the estate or someone else is going to.
That's a good point to raise, actually, because you typically, it's the requesting party who pays the fee. I have had cases where the testator had agreed in terms of business when they actually made the will that any sort of charges relating to this sort of activity would be paid by their estate. It doesn't happen an awful lot, but it's something worth checking when you're making that initial request, just to sort of, if you can sort of save a bit of cost here and there, it does help in the long run.
Absolutely. So just to sum up, obtaining the will file and the Larke and Nugus statement is a really crucial step in challenging a will and the validity of a will, but there can be a lot of confusion around it, and there can be delays and unreasonable charges, which can cause real problems right at the very start of a matter. Well, thank you, Jeremy. That's really, really helpful. Thank you for joining us. And as always, if you or your clients or contacts, family and friends have a situation like this and you need some assistance, please do get in touch with us here at Clarion. Thank you for watching.